books, but I remember a line from one of the books, and the line started out actually the second volume of the series, and the line was, "Consider a room." One of the cardinal rules that all of you need to remember when you start the voir dire process is consider the room where you're standing, because all of the behavior that you engage in with all the people in the jury box and the audience and so on will have everything to do with how that room feels to you. Are there windows in it? How is it lit? Where are your sight lines to the particular people? What are the acoustics like? How does the room come across to you? Will have a great deal to do with how you come across to the people that you're going to have to persuade. Everybody has probably told you in the course of becoming a lawyer, prepare, prepare, prepare. But a lot of the things that have been left out from teaching you about being prepared have very little to do with writing things down, filing pleadings, doing things that impress or involve a judge. And that's what I want to talk to you about this morning, because the first third of what I'm going to talk to you about is how you prepare to do this job, the job that I'm going to do with you this morning. Introducing yourself to a lot of people you don't know, conveying an impression of yourself, conveying an impression of your case, and trying to get people to warm up and empathize with you before the trial even starts. As persnickety as it might sound, if you know your room before the day comes that you have to try your case, you've already integrated into your thinking all the little ideas about how you can do the voir dire job more effectively. In my courthouse in Orange County, it was built in 1966, designed by an architect named Richard Neutra. And I'm absolutely convinced that nobody spent a dime on it since then. The problem with that is we have fluorescent tubes from 1966. We have dark wood paneling from 1966. We have acoustics from 1966. And I'm convinced we have judges from 1966. Some are hard of hearing. Most of them are cantankerous and intemperate. And very, very few of them like you to be a little too over-involved with the jury. These are all things that you learn before you start. If you don't do your homework at least a week or two before your trial by physically going into the courtroom where you're going to try your case and sitting there for an hour and in your mind visualizing, how do I feel in this space? How do the sight lines feel to me? What does the jury box look like? How would I relate to people that I don't know in this kind of a setting? Then when you go in, when this trial starts, all the focus is on you and you're going to clam up. If you leave today's session with me with one cardinal rule, that's it. If you do what I tell you in the sense of spending the time before you start the trial, and you get to know that room, then you're going to get to know those people. And if you don't, it's going to be a very forced and very distant and very, not adversary, but certainly a very separate kind of an existence you're going to live with those people that are going to make a decision. Okay, having said that, there are a couple of very basic human relations rules I'm going to talk to you about, and also some pointers and ideas about how you conduct the whole process of voir dire. You're going into a room with a lot of people you don't know. You're going into this room in a formal, somewhat studied, and in my opinion, artificial atmosphere. This isn't a party. This isn't a relaxed social get-together. And notwithstanding what a lot of books may tell you about trying to behave that way, in my opinion, that isn't the way to behave. Someone's paying you a whole lot of money to try to get their side across to 12 people you don't know. We all have different personalities in life. Jeff and I have become friends over the years that we've done this program together, and he and I are dramatically different people. He is looser than I am. He is more relaxed than I am. His sense of humor is always at the forefront of his personality. I'm a much more tightly wound, more buttoned down kind of a person. I'm nuts about detail. I have reams and reams of paper everywhere I go. I'm like that little comic book character that's got dust falling behind them. I have papers falling behind me. I know who I am. You all know who you are. If I leave you with another tip, don't be someone that you're not when you start to talk to a jury. You need to have a very clear idea of the kind of person that you project, so that when these people get to know you, they are convinced that what you're telling them is what you believe and what is the truth. Because oddly enough, the jury to an enormous extent draws its inferences and its impressions not from your client, but from you. And you have much more persuasive ability and power than you realize when you're representing someone. A lot of little things that go into making decisions about dress, about grooming, are all critical in this juncture because a lot of people you don't know are going to look very carefully at you. Long time ago, I had a trial in Los Angeles. It's the first jury trial I had in front of a guy named Charles Jones. And lawyer was on the other side, about 25 years older than me and very, very experienced. And he had read Robert Ringer's book, Winning Through Intimidation, and it had taken all of the principles to heart. So, and I apologize in advance if I'm embarrassing any of you, but he went up to me and he pulled my shirt and goes back and goes, "You sleep in that shirt?" Then he went over to me the next day and he goes, "Well, you lost a little weight. You a little worried about this trial?" And, you know, over the course of it, he goes, "Gee, you look a little pale. Are you eating well?" So after about 3 days, I was so green that I didn't know what to do, and then I got mad. And then I said, "You know what? I'm going to give him back exactly what he gave me." So I said, "Larry," I physically did this. I said, "I'm learning at the foot of the master." And he didn't know what to do. My point in telling you the story is somehow the essence of who you are as a human being is what is communicated to these people that you don't know. I don't want to give you a script. I don't want to say if you do A, B, C, D, and E, you will have effective voir dire. What I'm trying to inspire in you is a sense of plumbing your own depths to get a sense of who you are as a human being, and then finding a way to communicate that to people that you don't know. A couple other minor matters in that vein. If you don't like your case and you don't like your client, you shouldn't be here now, because you're not going to do a good job in convincing 12 people you don't know that they should go your way. Go get another lawyer to do the job or get somebody else to take your place, because when you walk into that room, you've got to feel that you should win. And if you feel that way, you're going to bond to a certain extent with your client. Now, no one's asking you to buddy up to them, throw your arms around them and say, "I think this person's great. I think you ought to give them the moon," or whatever, just because they're here. There will be things that you'll learn in the course of getting ready for your trial about your client, that if you really take the time to get to know them as a person, somehow they'll be communicated in your voir dire to the jury, particularly if you have a corporate client. One of the biggest problems that you face when you represent a company is that they are a faceless monolith. And you've got to find a way as lawyers to humanize that faceless face. The best way to do that is to pick one of the representatives of the company and talk to the jury a little bit in voir dire about what it means when a company is a client or a party in litigation, that a company is composed of or made up of human beings like you and me. They need to get a sense of who that person is rather than who that faceless non-entity is, because it's harder to say no to a person than it is to say no to a company. In that same vein, if you build a wall between you and your client in how you behave towards them in front of the jury during voir dire, the jury will sense that. And what I mean by that is you will create and convey a very distinct impression that you don't believe that your client's right, but you're just punching a clock and doing a job. And I'm here to tell you that that isn't what the practice of law is all about. This isn't about punching a clock at all. This is about the joy of releasing some part of you that wants to convey a message or an idea to people and to humanize that with a very, very scared client. One of the hardest things I had to learn when I became a lawyer was to somehow absorb and integrate into my own personality the degree of fear that a client feels when they're going to trial. The level of tension is huge in a jury trial. Everybody, including the jury, is tense. Humor diffuses some of it, but it is a fact of life and a reality that all of you have to know. Your client is placed into an arena that they don't know what to do. They don't have any sense of how they should behave. They automatically believe everybody doesn't like them, that the judge doesn't like them, and the judge oftentimes is on a raised dais and glowering down at them, particularly in federal court. You've got to be the rock for your client. When your client's tense and nervous, you've got to make the client feel, it's okay, we're going to get through this as a team and together. And in voir dire, You've got to communicate that to the jury. Now, I could give you all the little tips from all the books, for example. And I think in my materials, I copied some of the face pages of the more respected treatises in this field and left them with you so you have them. It isn't my intention to read from them or quote from them or tell you that one is better than the other. My job is to give you research treatises so that after you're done with me today and you want to know more, you have a place to go. But I will tell you, I don't know that you have to put your arm around your client. I don't know that you have to touch your client if that's not what's comfortable to you or what you want to do. But find a way to communicate to the jury that you've got respect for your client and that you believe in your client's case. Don't build a wall or separate yourself from your client like you're punching a clock, because if you do, the jury will. All right, I want to turn now to what I consider more nuts and bolts topics of exactly how do you conduct voir dire, because there's, in my opinion, a right way and a wrong way, and I may be held to task by my other faculty members or by you about that, but I do believe this very strongly. I want you to watch what this poor guy and I are going to do, and I'm sorry again to make you my guinea pig, and then I'm going to ask you some questions about how you would feel if you were sitting where he is. How are you doing?
Good.
Are you doing well?
Quite well.
How are you feeling today?
Feeling good.
Good. Are you glad to be here?
Super glad.
Are you good? Okay. If you were where he was, what's your reaction to what I just did?
Well, nobody wants to be confronted by anybody.
Okay.
Personal space would be not a good thing.
How many of you think I invaded his space? Good. Then I communicated my point. I have a brother who looks like my twin, and he also has a very different personality from me. And when we do that to each other, we call each other space invaders. And I do it to him deliberately just to provoke a reaction from him sometime, and that's why I did it with you. We all have a zone of privacy around us. Respect that with the jury. This isn't about Jerry Springer. This isn't about Ricky Lake. This isn't about how you impute to one of the talk show hosts, "I'm so cool." This is about a formal proceeding that you are in an adversarial relationship with someone else, convincing people you don't know about an idea. Respect that point when you talk to people. Okay, let me try another one. I promise I won't do it to you anymore. I'll pick some other poor person. Okay. Sir, I'm glad to see you today. How do you feel today? Good. Okay, well, maybe you made my point. Any reactions to how I've talked to him? Sir? Exactly, exactly. My next point. The wall that I've been trying to convey to you, that gentleman saw right away, that I built up between this man. Did you feel that at all or not necessarily? No. Okay. Well, my only point is that if you, as the lawyer who's doing the voir dire, puts a distance between yourself and the jury, where you're pedantic and particularly with the finger wagging and so on, that will inspire such antagonism you have no idea. And I'm probably as big a victim as anybody of telling stories, and I can't help it, but I like to think they help. I had a trial, 1984, against a guy who's my dad's age, who was a lawyer from Beverly Hills. Very handsome guy, flowing gray hair, and very full of himself, very imperious kind of a personality. And the reason I tell you that is I'm going to now do some more of the demonstration and show you why I want to bring it up. You agree to follow the law, don't you?
Yes.
Okay, and you will do everything the judge instructs you to, won't you? And you'll listen to me very carefully, won't you?
Yes.
Okay, what's your reaction to what I just said to her?
Sound like you're cross-examining her.
Okay, how would you feel if you were sitting where she was? Okay, most people feel that way or not necessarily? Okay, what I've done and what this man did was placed on his shoulders a mantle. I'm important and you're not. I'm the boss and you're not. I'm the one you have to respect and I don't have to respect you. Check your ego at the door. When you're in this room, this isn't all about me. This is all about you. So if you want to write down a note, I'll give it to you in one sentence. Avoid closed-end questions. Anybody want to tell me what I mean by closed-end question?
Questions that can be answered with yes or no.
Exactly. If what you're doing in this room is to find out as much as you can about someone, Asking them to answer a question, yes or no, will tell you nothing. Absolutely nothing. I sat through 3 hours. I didn't know how the hell the guy did it. For 3 hours, closed-end questions. I looked at him in utter astonishment. And I said to myself, I was very green, but I was saying to myself, you didn't learn anything about those people. And so I interviewed them exhaustively, which I really encourage you to do, win or lose in a trial when it's over. Grab some of the jurors, not physically, and say, what'd you think? What made you go the way that you did? And all of them said to me, we were, and I'm sorry to use a 4-letter word or foul language, we were pissed at that guy. He made us feel small. That's not what you want to do when you're in this room. You want the people to feel like they are the centerpiece of this because they're the ones making the decision, not you. Your role in this job, you're an interchangeable part. You're trying to be part of a larger thing to convince people of an idea or a set of facts or circumstances. By creating this pedantic posture, you're violating the basic canon of voir dire, which is to persuade people to like you, to understand you, and to communicate with you. All right, let's do this a little bit more. Do we have any water anywhere? A bottle of water anywhere? Thanks. Now, I'll give you a little preface to make this maybe a little more involving and a little more personal. In the last 2 years, I've had the unfortunate bad luck, if you want to call it that I've literally been on the eve of trial every time I've come up here to do this. And the Hastings people cut me loose. I was in the middle of a trial, and I came up here, and my identical twin brother literally sat in for me for 24 hours in the middle of a trial so I could come up here and do this talk. And God, the jury loved it. He was so funny and so relaxed, and I was so tense and so uptight. They were delighted to have a change of pace. Next Monday, I'm there, same courthouse, starting the trial. The good news was I had at the tip of my mind voir dire questions in my head because I had a pending trial. The audience had a ball because they were bugging me, well, what about this, what about that? And I was giving them very real input on how you do this job. So I'm going to tell you about my trial, and then we're going to go through some questions I'm going to ask you, and you're going to ask me. I'm defending a multimillionaire. Actually, I'm plaintiff for a multimillionaire who was living on what they call one of those mini mansion lots in Newport Coast, which is a very expensive subdivision down in Orange County. He's built a grandiose mansion right to the lot line, which the rules let him do. His next door neighbor has built a mini mansion right to the lot line, is also a multimillionaire. His next door neighbor built a 28-foot long by 12.5-foot high outdoor fireplace and barbecue. He built it 15 feet from my client's master bedroom window. When he lights up his god-awful barbecue, it vents smoke into my client's master bedroom. It also has this. Every time my client looks out his master bedroom, he sees the proverbial thumb in front of his nose, which is that ugly chimney. The association did nothing about it at the inception because the same builder owned both lots, and because the builder wanted to close on multi-million-dollar deals, signed off his own neighbor consent form because he was his own neighbor. Then he sort of didn't tell my clients, by the way, about 2 months after you move in, they're going to build this enormous thing. Closed on both, and he's down the road. Here my client is with this monstrosity dumping fumes into his house. Okay. What problems do you foresee with the jury taking a case like this? Maybe I'm giving my question away. Taking a case like this seriously.
Rich guy, everybody.
Okay, anybody else?
Built large homes, that's kind of the price today when you want to build out to the lot line, that's expensive.
Okay, anybody else? That man gets a $64 prize because, believe it or not, my biggest fear and my biggest problem is I'm going to get a jury composed of 12 guys like him who are going to say, they won't use Shakespeare's language, but a plague on both your houses, get out of here and go home. I am being well compensated. The other lawyers are being well compensated. I have never worked on a case where even I feel like, what am I doing here? What in the world am I doing here? What is this forum doing resolving this dumb dispute between two rich guys? Well, I'm here. You're here. Judge is here. He's not happy about either, believe me. He looked at me in complete disbelief at the mandatory settlement conference. He said, jury trial, 4.5 weeks? He goes, the taxpayers aren't going to like this very much. So I looked at him and I said, you know, you're not going to believe this, but I literally went off the rails trying to settle this case, and I couldn't. So, you know, so all my friends, I would tell them over a beer, and they go, look, God's smiling on you. You're going to make a ton of money this year because these morons want to use the courts to resolve these types of things. Well, what I'm telling you is I'm here. This is going to happen. Knowing what the four of you said to me by way of the infirmities in bringing a case before this jury, let me start with you. What kinds of questions would you ask a jury in trying to ferret out information you need to know about whether you want that juror to try this case?
I don't think I can answer you directly because I would take a different approach. I would try, through my questions to the jury, to humanize my client and make sure that the people could relate to him as a person.
Okay. That's a good point. I'm sorry, I'm pointing at the guy behind you, but that's a good point. What would you do?
I want to know if they had any experience with home building issues, if they were homeowners themselves.
Okay. Anybody else?
I want to know if any of them ever had disputes with their neighbors.
Good. Okay. What about you, ma'am?
Trying to figure out the socioeconomic status.
Okay. Anybody else? Okay. Let's build on something you, sir, said. Man, no, you're the right guy. Let's use for the moment the phrase or term, and I apologize in advance for the sexist nature of the remark, a man's home is his castle. If you adopt that as a basic tenet of your argument, how can you use that basic tenet in voir dire to communicate with the jury your point of view? Remember, you're plaintiff. You're the one that wants that thing yanked out.
Are you going directly against the next door neighbor? Are you going back and trying to find the developer, trying to do a homeowners association?
They're all in it. We settled with association Friday.
So this is neighbor versus neighbor.
Yeah, and the builder is squarely in the middle, but yeah. The builder is cozying up like you can't believe to the neighbor. They're fixing everything that could conceivably go wrong in the neighbor's house. Oh, let me get a carpenter out there. Let me get a plumber out, like yesterday. You know, of course, are they coming out to fix my guy's stuff? Not this week. Okay, anybody want to take a stab at that question? I'll use a person's home as their castle. Okay?
I haven't formulated the question, but I want somebody who thinks that following the rules is very, very important.
Good.
Somebody who complains about their phone bill, for instance, I want to ask, you know, if you have a phone company that promises to give you long distance service at 10%, and about 4 months later you discover that they're charging you 10 cents a minute, and you find they're charging you 14 cents a minute. What do you do?
Okay. The association didn't follow its own rules here. They didn't do it because they were somewhat beholden to a very wealthy builder who was responsible for getting a lot of product off the shelf. And they know it. They don't want to get in the middle of this, and they're composed of a lot of neighbors. They don't really want to get in the middle. But your point's well taken. The neighbor has to follow the rules too, don't they?
Right, that's what I was thinking.
I don't care how much money they have. Doesn't the neighbor have to follow the rules too? And that's my point. And that's the point you want to communicate to the jury if you're going to use your idea of following the rules. We all have to follow the rules. Nobody's above the law, no matter how much money they have. And if the courts are really supposed to protect people's rights, they protect poor people's rights and rich people's rights. And it doesn't matter how much money you do or don't have. What matters is, did they follow the law or not? That's my point to you this morning. That's the message you want to communicate when you talk to the jury. Let me give some thought to some other aspects of this examination. What don't you want on a jury? What types of jurors do you not want? Let me pick on you, madam. This. Okay, tell me why.
Two opinions, very judgmental stuff.
I don't agree with you. I don't think that's enough. And the reason I don't think it's enough is if your opinions are in line with mine, I want you big time. Now, how do I find that out? And I'm asking you again, how would I find out if your opinions are in line with me? Which would be what? Okay, anybody? All right, let's find out. We'll use you, and I'm sorry I do this, but this is the point of this whole thing. This isn't all about fun. This is about learning. And stick your neck out in the next 3 days. We'll all catch you. This is as warm and supportive a group of lawyers as you'll ever meet in your life. We want to make you better. Well, if that's not an oxymoron, right. I guess I had that coming. You've heard my discussion with the jury, madam, about basically what this case is about. What do you think about a case like this coming into court?
Oh, I think it was a valid argument. I don't, I agree with you that it's kind of big for the average person, but they absolutely have points.
Okay.
I don't understand. What is your question?
How do you feel about having this kind of case be heard in a court of law?
It needs to be.
Okay, tell me why. Just imagine yourself as a juror, not as a lawyer for the moment.
Because both of these people are being damaged in a certain way.
Okay. Based on what little I've told you about the case, do you have any feelings at all about who should win it?
Yes, sir.
Why?
Because the fireplace is not only obnoxious, but I'm sure it's other hazards as well. It's huge. It's the barbecue. Is that what it was? A barbecue?
Fireplace and barbecue. Okay.
And it's an environmental hazard, I'm sure.
What she's done is wandered real close as a juror to allowing any of you to bounce her for cause. And you could probably walk up to ask for a sidebar conference at that point and ask a judge to say, I'd like this juror excused for cause. And, you know, it'd be very hard to deny a motion like that because she's prejudged the case. The opinions have gone beyond just the opinions into having formed a judgment about who should win. These types of diagnostic questions will tell you a lot about a juror right away. How do you feel about this? Who do you think should win? Yes?
But since you had a good inclination that she might be going your way, did you make a mistake by asking that next question and setting your opponent up to be able to remove her for cause?
Yeah, probably. Probably. On the other hand, if I knew I was going to get hit, if I'm like, ugh, I know that she's going to go sideways on me, I might as well be the good person and just do it myself before it makes me look bad like I'm trying to cozy up to somebody. It's a judgment call you have to make based on your relationship with the juror and how they're coming across. But you've got a good point. I may very well have been able to take the risk and let it go in the hopes that they would miss it. How many of you know what the phrase do the calculus means in terms of human relationships? Any of you ever heard that? When you're having to make decisions on the fly based on your impressions of people, you have to weigh certain things. What's your relationship with that person? How's it going to come across to a lot of people? When you make decisions about what course of action you take, that's doing the calculus. That's what you have to do in a situation. How does she come across the other 11? One of the points I was trying to make to all of you when I unfortunately beat up this poor guy here in the front is I would be willing to bet if 11 others of you were with him in the jury box and I did, in fact, let me ask the question. How would you react if you're sitting next to him and you see me going like this to him? What's your take on that? Okay, good point. I agree. So that's going to happen in your calculus too. If I beat her up, then I run the risk of polarizing this gentleman as well, which I don't want to do. So I have to do the math in my head and decide that one as well.
On the other hand, if she's particularly adverse to your side, and you think there's a chance that some of the other jurors are going to be more favorable to your side, you might be improving that aspect without directly confronting this jury.
Never ever run from a fight. If a juror wants to take you on, don't run away. There are millions and millions of ways to defuse a hostile situation, and believe me, it's going to happen to all of you in Voir dire, where you're going to juror because they're smarter than you are and they want to show you up and make an example of you, or they hate lawyers for whatever reason, and there are lots of reasons. That may be something you have to do, as you correctly pointed out. You may have to gently without humiliating them, make an example of them to the other jurors. Let me put another thought in your minds for a couple of minutes. During the course of voir dire, some jurors may not want to answer your question. If you're wandering in fact, let me give you a demonstration on that too, so we can go through that. How much money do you make every year?
None of your business.
Okay. Now, and I'm sorry to make you my fall guy again, but how do you feel now that I asked her that?
No. Pretty much the same kind of feeling that I had before. You're nosy, I'm not looking forward to talking to you.
Right. All right. Now let me ask you, sir. Let's assume I go to the judge and I say, Your Honor, instruct the juror to answer my question. What's your reaction to that one?
I'm hoping that you're not going to do the same thing to me.
Okay. What do you think of me at that point?
I have a negative impression of you, and I think you're asking too many questions and too nosy, getting to the nut of business.
Does anybody think I have a right to know what somebody's annual income is on the jury?